Good morning, friends. My today topic is case law Narayan Pandey versus Pandalal Pandey. This is of 2012. The quorum of Honorable Judges is Honorable Justice R.M. Lodha and Honorable Justice Anil R. Dev. The sections which were taken into consideration were Section 35, Section 37, and Section 38 of the Advocates Act and Article 19 of the Constitution of India. For more details, you can go through equivalent citation, that is Manu SC 1087 of 2012. Friends, let us go through the brief of the case. In this case, the appellant filed a complaint against the respondent, an advocate practicing in Tehsil, Gyanpur, District Sant Ravidas Nagar, Bhadohi, under Section 35 of Advocate Act 1961, before the Bar Council of Uttar Pradesh, alleging that he is involved in a number of false cases by forging and fabricating documents, including settlement documents, without the knowledge of the parties in the consolidation court. The complainant further alleged that beside the cases of other people, in the case of complainant also, without his knowledge and other co-khatedars, the respondent advocate filed a compromise deed by forging and fabricating their signatures and obtained orders from the consolidation court. The complainant gave the details of the four cases in this regard. The complainant also stated in the complaint that respondent advocate has been earlier held guilty of professional misconduct and in this regard referred to the judgment in the matter of Devakar Prasad Shukla versus Pannalal Pandey. Complainant prayed that the respondent advocate be proceeded with the professional misconduct and be punished by cancelling his license to practice. So this complaint was referred to disciplinary committee by the Bar Council of UP. The respondent filed a written statement to the complaint and denied the allegations made in the complaint. Respondent denied that he had forged signature or created any fictitious compromise document. He set up the plea that complaint has been filed against him due to enmity. Friends, after going into the details, they allowed the appeal of the complainant and held the advocate guilty. So, the Honorable Court in Para 32 observed that the punishment for professional misconduct has twin motives, objectives. One is deterrence and other is correction. So, in light of the above legal position, we now consider the quantum of punishment. We have restored the finding of the disciplinary committee of Bar Council of UP. That is, the respondent advocate was involved in a very serious professional misconduct by filing wakaltnamas without any authority and later on filing fictitious compromises. The professional misconduct committed by the respondent is extremely grave and serious. He has indulged in mischief making. An advocate found guilty of having filed wakaltnamas without authority and then filing fictitious compromises without any authority deserves punishment commensurate with the degree of misconduct that meets the twin objectives, that is, deterrence and correction. Fraudulent conduct of the liar cannot be viewed leniently, otherwise the interest of administration of justice and highest traditions of the bar may become casualty. By showing undue sympathy and leniency in a matter such as this, where the advocate has been found guilty of grave and serious professional misconduct, the purity and dignity of the legal profession will be compromised. Any compromise with the purity, dignity, and novelty of the legal profession is surely bound to affect the faith and respect of the people in the rule of law. Moreover, the respondent advocate had been previously found to be involved in a professional misconduct and he was reprimanded. Having regard to all these aspects, in our view, it would be just and proper if the respondent advocate is suspended from practice for a period of 3 years from today. The order passed by the disciplinary committee, BCI, is modified and a respondent advocate is awarded punishment for his professional misconduct. Civil appeal is allowed to that extent with no order as to costs. The registrar shall send copy of the order to the Secretary State Bar Council, Uttar Pradesh, and Secretary Bar Council of India immediately. So this is short video, friends, on professional misconduct of the advocate. I hope the those advocates who are having such mindset will take lesson from this video and try to maintain the decorum of the court as well as the noble institute of advocate on record. That's all. God bless you all. See you again.